Court of the State of Nebraska is now open for the transaction of business. Draw nigh, all ye having business with this honorable court, and ye shall be heard. God save the State of Nebraska and this honorable court.
Thank you. You may be seated. Good morning to everyone. We will begin with introductions by members of the court. I am Mike Havican, the Chief Justice, and now, by order of seniority as to service on the court, the other members of the court will introduce themselves.
Good morning. I'm Lindsay Miller-Lerman.
William Castle, good morning.
Stephanie Stacy, good morning.
Good morning. I am Jeff Funk.
Jonathan Papik, good morning.
And John Freidenberg.
Thank you, members of the court. Our first case today is State versus Boswell. Both sides have up to 20 minutes on this case for arguments. Mr. Lancaster, good morning to you. And Ms. Faust, before you begin. Ms. Faust, good morning to you. Do either of you have questions before we begin?
I do not, Your Honor.
Thank you then. Mr. Lancaster, you may proceed.
Thank you. Good morning. May it please the court, counsel. I am Todd Lancaster. I'm with the Nebraska Commission on Public Advocacy. I represent Betty Boswell. I've represented her at trial and on this appeal. She was charged and convicted of 3 counts. One is murder in the first degree. The other is unlawful disposal of human remains and conspiracy to commit murder in the first degree. The state filed notice of aggravating circumstances at the beginning of this case seeking a death sentence. The panel in this case did not find unanimously that the aggravating circumstance was proven, and she received a life sentence. This case result kind of comes out from the disappearance of a 24-year-old woman named Sydney Loofe. She had disappeared after being on a date that was set up through social media. She'd gone on a second date with the person and posted on the media about this, and then she went missing and disappeared. Investigation into the case tracked her phone from her residence in Lincoln to a area in Wilbur. It was discovered that the person she was on a date with was Bailey Boswell in this case. The investigation then tracked her phone and the Boswell trail phones to various areas, including areas alongside a highway where the phones were shown to be moving and stopping. As a result of that, law enforcement investigated those areas and found garbage bags on the side of the road and in the ditches, which contained the remains of Sydney Loofe. The investigation also revealed that there were 3 women, Ashley Hills, Anna Goliakova, and Caitlin Brandel, associated with Trell and Loofe. Their testimony was that Trell and Boswell contacted them through social media. They became involved with them in a submissive, dominant relationship where the women had to do certain things, obey Trell, call him daddy, contact them whenever they were away for 1 to 3 hours, participate in sexual activities, and they would receive basically allowances for this. And they would receive punishment if they violated the rules, including being smacked, punched, choked, spanked, having a belt used on them, or their allowance taken away. They all talked and testified about the activity they participated in, including helping Trell in his antique business, which was basically stealing antiques, and the sexual activity they participated in, and the things Trell talked to them about in regards to witchcraft and the occult. Prior to trial, several motions were filed, motions in limine to keep out certain evidence, including a number of gruesome photographs, testimony or evidence about sexual behavior or sexual deviant type behavior, talk about witchcraft or the occult, and hearsay statements made by Trell through the conspiracy.
Which specific hearsay statements are you focusing on appeal? You reference them, but you sort of reference them generally, and this is a big trial record, and it's not clear to me which specific statements you want to focus our attention on.
Statements about Trell to the 3 women, Ashley Hills, Anna Golikova, and Caitlin Brandel, about witchcraft, about Bailey Boswell enjoying things like having painful sex, being sexually excited about talk of torture during sex, statements from him concerning witchcraft, that Bailey Boswell was a witch, that she was able to leave her body.
I beg your pardon, are you most focused on Hill's testimony?
Hill statements,
Or,
also
yeah,
some,
Hill's vis-à-vis the non-hearsay exception, that's.
right. The statements that came in through Ashley Hills, Anna Golikova, and Caitlin Brandrell, that were made to them by Aubrey Trail.
Hill's as compared to some of the other women who spoke?
Well, Hills, I think, had the most information about things that Aubrey Trail talked to her about, things about Bailey Boswell being a witch, that she has special powers, that she also could become a witch by doing certain things, that she could gain powers by participating in a killing and taking the breath of somebody. These statements that Trail is making to Hills that then were brought in at trial about some of the other stuff that we objected to, the witchcraft, the occult, the sexual behavior and demeanor and things that they did.
So are you objecting to the testimony or when the testimony came in, or both?
Both. Objecting to the testimony coming in, not only because it wasn't relevant, because it's talking about the witchcraft and it's talking about sexual proclivities, which I argue is basically character evidence about Bailey Boswell.
Do you think, I beg your pardon, are you saying it's not truly non-hearsay under 801-4B?
It's a little complicated because it's wrapped up in all the other stuff that is not relevant because of the nature of it, the sex talk, the talk about witchcraft. Also, the argument that we made is that the state had not proven up the conspiracy prior to allowing those statements to come in.
Didn't the judge make an express finding that the conspiracy, the existence of the conspiracy had been proven by prima facie evidence before the three young women were allowed to testify about anything that Trail said?
She did make that finding
Why was it
after-
insufficient? Why was that finding insufficient in your?
In my opinion, that was insufficient because the findings that there was a conspiracy, for example, the talk about the woman that they met at Walmart that was going to be picked out by Ashley Hills to kill, basically. There was really nothing other than talk about that. There was no overt acts that there was a conspiracy. This is just Aubrey Trail saying, oh, this is a person we picked out for you to kill so you can gain their powers through this witchcraft thing. There was no evidence that there was actually a conspiracy, that they had picked this person out in advance, that they made any kind of plans to actually, commit a murder with her. It's just Aubrey Trail saying, oh, this is who we picked out, and this is going to be the first person you can kill. There's no conspiracy at that point to commit a murder. It's just Aubrey Trail talking. I feel that was insufficient to prove by prima facie evidence that the conspiracy was in effect. Sure, there's other talk about, they like to talk about, what would you do if you could torture somebody and things like that, but that's not, in my opinion, in my argument, that was not evidence of a conspiracy. That's just talk about sexual fantasies that they have. That there's no other evidence that there was conspiracy at that time, other than Aubrey Trail talking about, this is who we think we're going to pick out for you to kill. And using his statement to prove up the conspiracy. I think the law is they have to prove the conspiracy by independent evidence.
Isn't the evidence that they are in Walmart and they are looking at someone, isn't that evidence of the conspiracy itself without any testimony about what people said?
That could be evidence, but I think at the time they were my recollection of the record was at the time that they were bringing in Ashley Hill's statements about this, that evidence had not been presented to the jury yet. That this was evidence that presented later and not presented before they allowed the hearsay statements to come in. And I think this court has said that there has to be independent evidence of the conspiracy outside the hearsay statements that you want to bring in to prove the conspiracy first.
So
But
what
the
did
overt act is I believe, is what the fact to which the chief is referring, which is separate from statements. I
Right.
beg your pardon, Justice Hook.
what did the district court rely upon in making its determination that there was sufficient evidence of a prima facie case of conspiracy?
It appears the court was relying on statements about talk that, for example, that Aubrey Trell asked Ashley Hills, if you want to kill somebody, who would you kill? Or talk about sexual fantasy stuff, like if you could kill somebody and do something, what would you want to do that? That the state's relying on that.
But what did the district court rely upon? What evidence had been presented before these three women testified?
It appears to me that before, my recollection of the record is that those statements were allowed to come in before the other evidence, such as what the chief has said is the going to Walmart, buying things, that kind of stuff. My recollection is those didn't come in until after those statements from Ashley Hills were brought in.
Didn't the three women testify almost at the end of trial?
It was towards the end of the trial. They testified, I believe, Ashley Hills testified, and there were other witnesses, police officers, that sort of thing. And then Golikova and Brandel testified towards the end, but before the pathologist testified.
So the jury already heard testimony about what was purchased at Menards, about pursuing the victim through Menards, about the forensic evidence at the crime scene, all of that. Had they heard all of that already? The cell phone evidence?
They certainly had heard all the cell phone evidence before that. The evidence that the phones had sort of paralleled City Loose travel through town before, and that the phones had been tracked where they found the evidence of the remains on the side of the road. I believe all that did come in before those statements came in.
Did the trial court rely on some of that evidence, what the judge described as the overt acts of Boswell and Trail in supporting the conclusion that a conspiracy had been proven?
I believe might have relied on some of that. My recollection of the judge's order after I objected and she said she was allowed in was, at this point, I believe there's been enough evidence to show that there's a conspiracy, so I'm going to allow the hearsay testimony to come in. I wasn't very detailed on what she was relying on in making that determination. Didn't say specifically A, B, and C, I don't recall, so. I know the hearsay kind of jumps back to the end of my argument and stuff, so if there's no other questions, I'll go on to some of my other, I guess, arguments, particularly about the number of photographs. This court has obviously said that photographs, even if they're gruesome, if they're relevant, could come in to show the condition of the body, the extent of the wounds, and establish malice or intent. I think that comes from the last case that this court heard, which was State versus Britt. In that case, 13 photographs were shown that were objected to. Another recent case, I think it was State versus Stella. In that case, 8 photographs were shown. In those cases, multiple photographs were shown, and they were duplicative, but were allowed to come in because they showed different angles. There was an argument about multiple different calibers of guns. In this case, over 50 photographs of the dismembered remains of Sidney Loofe were put into evidence. And that doesn't include the 8 X-ray photographs showing her severed remains through X-rays. Objections were made to all of these, particularly photographs of the head. There were 10 separate photographs of Sidney Loofe's dismembered head shown from various angles, from the left side, from the right side, a picture of her with grass still in her mouth, pictures of the back of her head, multiple pictures, at least 2 of her eyes, which were open, one showing both eyes, another one showing a separate eye.
How many of those pictures were from when the body was located, and how many were from pathology pictures?
14 of those pictures were shown, were from locating the remains at the scene. So 14 of those were shown of basically, here's a body part or body parts in a bag where we found them. Then they showed from the scene also multiple pictures of certain body parts from a distance and closer up from the scene as well. The rest of the photographs
I beg your pardon,
were,
I was going to ask about Exhibit 616. Is that the autopsy series?
I believe that is. The rest of the photographs were from the autopsy, which were shown through a PowerPoint through the pathologist. I don't recall exactly right now what 616 was. But I know the x-ray started at 617. They did show, and which was concerning to me, is that they showed so many pictures of the severed head, and it's horrific. And I had planned to maybe put those up on the screen for this court to see, but I had that discussion with other attorneys in my office, and they decided, well, this court has already looked at those, there's no reason to do that. That's what the state did when they showed it to the jury. But they are horrific. I mean, they are hard to look at. And the jury saw 10 pictures of the severed head, and no reason to show all 10. The state says, well, it shows this particular thing, or from this angle it shows another thing. You could show that by showing 1 or 2 pictures. The other thing that concerned me was that...
Did the judge exclude some pictures?
The judge excluded 3 photographs. One was, I believe, the forehead of the severed head. One was of one of the feet, and I forget what the third one was. So she did exclude 1 picture of the head, but allowed 10 others to come in. The identifying part of the case obviously goes to the severed upper forearm, which had a tattoo on it that was very distinctive. Obviously, a picture of that could come in to show identity. They showed 5 pictures of that at various stages. A couple at the scene. What had happened is they found that arm in a bag. It was late. They didn't do anything to secure it or cover it. They put an officer by the road, and the next day came out, and it had been moved by some kind of predator. So they took another picture of that, and another picture of that, and then they took 2 more from the autopsy and showed all of those to the jury. Clearly, there's some relevance to showing that picture for identity, but showing it 5 times, there's not.
Weren't there also cuts around the tattoo that were discussed in the autopsy findings?
There were small
those relevant
incisions
to the crime?
around, and I'm not sure what the relevance of that was. The state says it's to show intent or motive. I don't quite see how that is, and I don't see why they need to show it 5 times to show that. They showed a picture specifically to show that there was animal predation on the arm. I don't see how that's relevant to the crimes and the charges that we're facing, to show that animal predation. Another one that was really concerning to me was a picture of the chest area of Sidney Loofe. So it was basically a naked picture of the breast area that had one of the nipples had been chewed off by an animal. Why did the jury see that? How is that relevant in any way? Other than to show these pictures to the jury, to horrify them and rile up their emotions about this. And that's the concern of showing so many pictures. If we allow the prosecution to keep showing so many pictures to get the jury's emotions up, they keep doing it, and they keep going more and more. Again, in Brit there were, I think, 8 pictures. Here there's 50. It's hard for me to see how that is not excessive and why all 50 of those pictures need to be shown, other than to horrify the jury and get them to thinking about those pictures and not the evidence that the state has to show if they can prove that the actual murder happened. And my argument also goes to, and again, these are all very interlinked, I think, the arguments about the witchcraft and about the sexual conduct, I think, goes towards the same kind of idea. Let's get the jury thinking about Bailey Boswell as somebody who is sexually deviant, who participates in this weird behavior, anal sex, putting items in somebody's body and inflating it, lesbian sex with women, all this kind of strange stuff. Let's talk about how she's a witch, how she talks to other witches, how she can astral project her body. Let's talk about the defendant with all these character type things, which aren't relevant, just to have the jury think this is a person who's deviant and a witch and a morally bad person. So of course they're committing this murder. And you throw that on top of the jury who's been riled up by all these photographs. They're not going to be looking at the evidence. They're going to be looking at the deviant behavior and their emotions and not judging the evidence what it is. I'm going to save the rest of my time for rebuttal, if I may. Thank you.
Thank you very much. Ms. Faust, good morning to you.
Good morning. May it please the court, counsel. My name is Stacey Faust. I'm Assistant Attorney General representing the appellee of the state of Nebraska in this matter. Boswell assigns 4 errors on appeal. She claims that the district court erred when it admitted over her objections: 1, gruesome photographs; 2, evidence of what she deems to be sexual fantasies and deviant sexual practices, along with evidence of discussions of torture during sex, descriptions of sexual conduct and of sex toys; 3, evidence of witchcraft and other supernatural phenomenon; and 4, trail statements under the co-conspirator exception to the hearsay rule. The state's position is that the district court did not err when it admitted the evidence and that all of Boswell's assigned errors are without merit. I will start first with the conspiracy. The court found the state had proven a prima facie case of conspiracy because of the acts of Trail and Boswell and through Boswell's statements. The state argued that the prima facie case of conspiracy had already been proven by the time of Hill's testimony, because Boswell and Trail worked together to find women on Tinder, and because of Boswell's statements that she would help Hills find her first kill and that she wanted to be attracted to that victim. And Hills understood that the girl in Beatrice was to be her first kill. Contrary to Boswell's assertions otherwise in her brief, the court did not consider Trail's statements in determining the existence of a conspiracy. And as I said, the state did prove a prima facie case of conspiracy before Trail's statements were admitted. It was not only because of the evidence that the state actually argued met the prima facie standard, but all the evidence specific to Loofe's murder, along with the fact that each girl's name had already come up during the investigation. So Boswell's arguments are without merit. But the real reason I want to talk about this assigned error is just to discuss why Boswell's arguments are wrong as a matter of law. This court has repeatedly stated, most recently in Camacho in 2021, that before a trier of fact may consider testimony under the co-conspirator exception to the hearsay rule, a prima facie case establishing the existence of a conspiracy must be shown by independent evidence. The purpose of requiring that the conspiracy be established by independent evidence is to prevent the danger of bootstrapping. Those propositions suggest 2 things. 1, that the co-conspirator statements cannot be part of the court's determination as to whether a conspiracy existed, and 2, that there is a required order of proof and that the independent evidence of the conspiracy must precede admission of the statements. Neither is true, and obviously both the district court and the parties believed them to be true. In Borgelli versus United States, the U.S. Supreme Court found that in determining whether a statement is admissible as a statement of a co-conspirator, a court may consider the statement itself. This court in 2011 recognized that lack of prohibition on bootstrapping in State versus Pullins.
Were we talking about the co-conspirator rule when we were discussing Bourgeois in that context, or were we talking about a different hearsay rule?
You're talking about excited utterance, but I think bootstrapping regardless of the hearsay exception I think that you're talking about. But then after this case was tried, this court explained in Camacho in 2021 that indeed the statements could be part of the court's determination so long as there was also evidence independent of the statements to show the conspiracy.
And in that case, were we talking about appellate review, what the appellate courts could consider, or were we focused on the trial court's decision-making?
You were focused on the trial court's decision-making. And while the preferred order of proof may be that the independent evidence precede the statements, the actual order of proof is actually up to the discretion of the trial court. This is in accord with, 1, this court's precedent in State versus Henry in 2016, wherein this court stated there is no bright line requirement that the independent evidence of the conspiracy must precede admission of the statements. 2, this court's precedent that an appellate court looks to the entire record rather than only what was in evidence at the time the statements were admitted. And 3, the law in other jurisdictions cited to in my brief. Accordingly, the state requests the court in this opinion to disapprove of the language in those propositions and to make clear that 1, the statements can be part of the court's determination so long as there's independent evidence to support the conspiracy, and 2, there is no required order of proof. The law then allowed the trial court.
So what happens to the state if there is no independent evidence?
If there's no independent evidence, then the court's going to have to instruct the jury to strike the testimony, instruct the jury to disregard it, and we presume juries follow instructions.
Would that be proper for a mistrial as well?
I think it would depend.
Or a directed verdict?
I think it would depend on the evidence and the other evidence in the case supporting guilt. The law then allowed the court to consider, and allows this court to consider, all the testimony from all three girls in establishing the prima facie case of conspiracy that extends from the beginning of Hill's testimony all the way to Brandel's, which was when Boswell and Trail were ultimately arrested. She was still part of their group at that time. I will next address the gruesome photos. Boswell claims that the photographs from the disposal scenes and from the autopsy of Loofe's dismembered body parts were unfairly prejudicial and needlessly cumulative. Regarding the photos themselves, I think the state and the court did exercise extreme discretion. The state introduced a total of only, I think it's 15, not 14, of 87 disposal scene photographs and only 35 out of dozens, if not 100 or more, autopsy photographs. The photographs and the trial testimony show that each photograph was different, even if the same body part was depicted, and that each was omitted for a proper purpose. Importantly, the state did not need a separate purpose for each photograph, and it was entitled to present a coherent picture of Boswell's crimes, generally choosing its evidence in doing so. Boswell did not get to sanitize her crimes by picking the state's evidence for it. The purposes of the disposal scene photographs were to show identification, the condition of each body part as law enforcement found it, to assist in determining which parts had been subjected to animal predation, and to document the recovery process. To me, the photographs were essentially crime scene photographs. The difference here is that because of Trail and Boswell's actions, there were actually multiple crime scenes with multiple body parts, and the state was entitled to present each one to the jury. The autopsy photographs were all relevant to the condition of the body and to the nature and extent of the wounds and injuries to it. I think what's important to remember in that respect is that this case involved not just a premeditated murder, but a premeditated and deliberate dismemberment into 14 pieces, the removal of organs and structures, and disposal that subjected the body parts to 3 weeks of harsh winter conditions and animal predation. The actions taken by Trail and Boswell complicated the process of the cause of death determination. Dr. Loofe could not say, and the jury could not find, what happened to Loofe was anything other or anything in addition to strangulation unless she examined each and every dismembered body part, every cut versus animal predation, and then explained her findings to the jury. And she testified that all 35 photographs, in addition to the 8 x-rays, helped her explain those findings to the jury. The photographs of the points of dismemberment and the skin markings were especially probative of malice and intent and of the conspiracy charge because they evidenced the type of instruments that Trail and Boswell purchased together the morning of Loofe's murder, and they showed the pleasure taken in the dismemberment, which goes to the sexual gratification theory of the conspiracy. The 2 photographs showing together Loofe's reassembled body were not only relevant for identification and condition of the body, but they illustrated the careful dismemberment to show that this actually was planned along with the murder and wasn't a concealment after the fact case. For those reasons, I believe that the gruesome photos assignment of error is without merit.
Counsel, you would agree, would you not, that it is possible that there could be too many photos?
In another case,
Yes.
not here.
How is a trial court, how is an appellate court to review what that threshold is?
I think you go by the standard of review, and it's abuse of discretion here. It's a very high burden for Boswell to meet. And I think based on this case, when you look at the facts of the case, this isn't like a single gunshot wound case And even in those cases, we see more than one crime scene photograph, more than one autopsy photograph. This is a 14-piece dismemberment of body parts left subject to nature. And so it changes the analysis of how many photographs are necessary to present the state's picture to the jury. And I think based on those facts, based on the discretion that was exercised in the number of photographs, and based on the proper purposes of the photographs, Boswell cannot meet her burden to show that the trial court abused its discretion.
Thank you.
Lastly, with regard to the alleged Rule 404 evidence, I think it's important to understand that to understand Loofe's murder, we must understand the conspiracy. And to understand the conspiracy, we must understand the recruitment process of the girls. The sex-related, as I described it in my brief, the sex-related evidence and the witchcraft evidence from the girls was inextricably intertwined to the crimes charged because the evidence formed the factual settings of the crime, was so blended or connected to the crimes, and was necessary for the state to present a coherent picture of the crimes. That is because the evidence was necessary to not only understand the charges of the conspiracy and of Loofe's murder, but also to expose the lie that Boswell was just another victim of trails. To begin, it's important to also understand that the charged conspiracy was not specific to Loofe. It was a broader conspiracy. The state's theory was that Trail and Boswell conspired together to kill and mutilate someone, not just Loofe, for sexual gratification. Part of the conspiracy was to meet girls on Tinder who lived in the area and get them to kill with Boswell and Trail. But one cannot simply just ask someone to be part of a group that kills. So to truly understand the conspiracy, one must understand the recruitment process undertaken by Trail and Boswell. It started just a month after Trail and Boswell arrived in Wilbur, and it continued into November with Brandel. It was a process that entailed a sort of grooming and a pushing of the girls' boundaries. The question was, how much control could they have over these girls? Could they get them to kill? The process with each girl began with them agreeing to enter into a relationship with both Trail and Boswell, even though the girls weren't really interested in Trail. That was pushing boundary number one. The grooming began with money and favors, but the relationship with favors also came with rules and punishments for disobeying, and still the girls stayed. That was pushing boundary number two. The atypical sexual conduct, as Boswell calls it, began almost immediately into the relationships. Having sex with Boswell in Trail's presence and letting him touch them, committing sexual acts on Trail at Boswell's direction, taking sexual punishment, etc. And still, the girls stayed, pushing boundary number three. And then it was time to carefully introduce this idea of killing to the girls through the ridiculous witchcraft and supernatural talk. Hills was the only one who really bought it, but still all the girls stayed, pushing boundary number four. And then that kind of talk led to the graphic discussions of torture and mutilation and killing that turned Boswell on sexually. And still the girls stayed. That was pushing number five. And then it was time to test the girls. Would they follow through? Would they kill? And 2 out of the 3 girls were in. For Hills, it was the girl in Beatrice. For Brandel, it was Goliakova and a student in Kearney. For different reasons, they just never came to fruition. And that brings me to my second point. One cannot fully understand Loofe's murder without understanding the conspiracy that surrounded it. The girls' testimony revealed the sexually motivated explanation for Loofe's murder. Without their testimony, we were left to believe that her murder and dismemberment was this inexplicable act of random violence, when in reality it was an overt act committed in furtherance of the broader conspiracy to kill and mutilate someone for the purposes of sexual desire. Their testimony also gave context to or provided explanation for the dildo and crotchless sauna suit found in the same areas as Loofe's dismembered body parts, namely her donut of skin, as Dr. Loofe called it, which included her stomach area. Their testimony about the dynamic of their relationships with Trail and Boswell highlighted that Loofe was indeed a target from day one. Trail was known to those girls immediately and was part of the relationship with Boswell immediately. Boswell purposely hid Trail's existence from Loofe.
Can I ask you something regarding two separate assignments of error, or are they blended? Maybe that is my question. Could you have a conspiracy sufficient on this record without witchcraft? Assignment of error, I believe, 3 is witchcraft 404.
Yes.
But moving down to the next assignment of error with the admission of Hill, what Hill says, Trail said, in the context of it being part of the conspiracy. So I think my question is, can you have a conspiracy without evidence of witchcraft?
You could, but I don't think that means it was inadmissible. And that's because the witchcraft was part of the recruitment process. It was initiating this idea of killing to the girls, and would they buy it? And if not, because Hills did, right? Do we have to switch it up to be able to convince them to come along this ride with us to kill other people for sexual gratification? So it's interwoven in with the conspiracy, the recruitment process.
Could the admission of the witchcraft be error but harmless?
Yes. But it doesn't mean it wasn't relevant or inextricably intertwined.
Did the
in my
judge
opinion.
give instructions in regard to, for example, the witchcraft? Did she say something to the jury about it?
There is a limiting instruction on motive and intent. Yes. The court, in its order pre-trial, kind of took a shotgun approach of it's inextricably intertwined, direct evidence, and or if it is 404, then it's admissible for motive and intent. The state doesn't disagree with that. It's an alternative argument, though, because the state very much believes that all of it is inextricably intertwined. We have to talk about all this. This is the process that Boswell and Trail undertook with the girls in order to recruit them, in order to kill with them. My third point as to the Rule 404 is alleged Rule 404. We will never know exactly what happened during those 24 minutes that Loofe was in Trail and Boswell's Wilbur apartment. But according to Boswell, she was just as much a victim of Trail's as the girls were. And the girls' testimony showed that is a bold-faced lie. She participated, if not led, every single aspect of that recruitment process with Trail, which also evidenced her participation and thus her intent in killing and dismembering Loofe. If there are no further questions, we ask you from the judgment of the district court. Thank you.
Thank you. Do we have time for rebuttal?
Yes, Your Honor, 1 minute, 41 seconds.
1 minute and 41 seconds. Mr. Lancaster, we'll give you 2 minutes.
All right, thank you, Your Honor. First, I want to respond. I think a question from Justice Stacy was, can the appellate court look at all the evidence of the conspiracy, or does the trial court only look at the stuff before the hearsay statement or the co-conspirator statement is put in? I think clearly from State versus Camacho, where this court said, we have noted that on appellate review, we looked at the entire record rather than only what is evidence at the time the statement was admitted. So I think the rule is the appellate court can look at all the evidence to determine if there was a conspiracy, but the trial court has to look at whether the conspiracy has been proven prior to letting in the co-conspirator statement. I think Camacho is pretty clear on that. The discussion of this brings up the idea of, well, what if the statements come in?
So, counsel, are you arguing that a conditional admission of evidence is simply not permitted with respect to co-conspirator evidence?
What I'm saying is that before the trial court can let in the statement of the co-conspirator, I think the rule is the state has to prove by prima facie evidence that the spirit conspiracy has been committed first. Doing it otherwise is kind of putting the cart before the horse. And it creates a problem if you let the statement in prior to the proving up of the conspiracy. Why don't they never prove up that conspiracy?
That's a risk the state takes, isn't it?
And what is the result? Does then the defense ask for a mistrial, and there's a mistrial because that came in prior to the conspiracy being proven? Because I don't think a limiting instruction telling the jury to ignore that statement now is going to be sufficient. I think it would result in a mistrial if that did happen, which obviously creates problems for the defendant and the prosecution and the court. So that's why I think the rule as it's stated in Camacho should be the way it is.
Can you point to any other area of evidence where we don't allow a conditional admission? In other words, upon a representation that witness X is going to testify to something that's a condition to the admission.
Right offhand, right now, I can't. It's not something I looked into. But I understand what you're saying. It may happen in other areas, but I think the rule, as it applies to the co-conspirator statement coming in, and the way it's been handled by this court with the bootstrapping rule and making the conspiracy being proven before the statement comes in, is the right way to do it. And it creates less problems for the trial court and everybody involved if it is done that way. My feeling anyways.
Thank you.
If there's no other questions, I will submit it. Thank you.
Thank you very much, counsel. That concludes arguments in State versus Boswell, so you are excused.